March 7, 2024, 4:58 am Eastern Standard Time. 18 miles northwest of the United States Capitol, a convoy of unmarked federal vehicles, 7 black Chevrolet Suburbans, 3 armored tactical transports, and a mobile forensic processing unit cuts through the pre-dawn darkness along a private access road in Great Falls, Virginia. The road is unlisted on Google Maps. It does not appear on any county planning document filed after 2016. It terminates at a wrought iron gate fitted with biometric access controls, flanked by limestone pillars bearing no nameplate, no address, no identifying marker of any kind. Beyond that gate sits a 14,200-square-foot colonial revival mansion on 6.1 acres of landscaped grounds. Fairfax County property records list its assessed value at $9.4 million. Ownership is registered to an entity called Meridian Strategic Partners, LLC, a Delaware-incorporated shell company whose sole registered agent operates from a virtual office suite in downtown Wilmington. The company has no website, no employees on record, no listed phone number. At 5:03 am, FBI agents from the Washington field office, accompanied by specialists from the Bureau's Human Trafficking Task Force and the EAR's Criminal Investigation Division, breached the front entrance under the authority of Federal Search Warrant 2024 SW0287, issued by a magistrate judge in the Eastern District of Virginia. The warrant authorizes the seizure of financial records and electronic communications equipment related to suspected money laundering. What agents find inside will redefine the scope of this investigation entirely. Past the marble foyer, past a living room decorated with original oil paintings and furniture that a later appraisal will value at $340,000, down a corridor lined with photographs, their occupants smiling beside senators, ambassadors, Fortune 100 executives, a former vice president, through a concealed door behind a floor-to-ceiling bookcase in the private study, activated by a magnetic switch hidden inside a hollow copy of Marcus Aurelius's Meditations. A staircase descends 18 steps into the basement. There, federal agents discover the operational nerve center of a criminal enterprise that has been running beneath the surface of American political life for nearly 14 years.
The discovery. The basement is divided into 3 rooms. The first contains a bank of 6 servers mounted in climate-controlled racks, connected to a dedicated fiber optic line that bypasses the property's residential internet service entirely. The second holds a commercial-grade document shredder, a currency counting machine, and a floor safe bolted into the concrete foundation, inside which agents recover $3.1 million in cash, vacuum-sealed in packets of $50,000, alongside 22 prepaid debit cards loaded with amounts ranging from $8,000 to $25,000 each.
The third room is an office. Inside that office, stored on an encrypted solid-state drive connected to an air-gapped workstation with no network access, agents discover a database. It is organized with corporate-grade precision. Client profiles, transaction histories, scheduling logs, communication records, operational protocols for recruitment, transport, security, and financial processing. It is, in effect, the complete operational ledger of a $120 million nationwide escort and trafficking network, one that has served some of the most powerful figures in American public life. The database contains 512 client profiles. It spans transactions dating back to 2010, and it is cross-referenced with a classification system that sorts clients into 4 tiers based on their political influence and payment capacity. The highest tier is labeled Sovereign. It contains 37 names. The architect. The man who built this empire was already upstairs when agents arrived. He had been asleep in the master bedroom on the 2nd floor, beside a nightstand holding a Mont Blanc pen, a leather-bound personal journal, and a glass of single malt scotch with the ice not yet fully melted. His name was Vincent Paul Hargrove. Age 61. Harvard Law, class of 1988. Former senior partner at a white shoe lobbying firm on K Street. founder of a nonprofit organization dedicated to combating child poverty in Appalachia. Three-time recipient of the Washington Business Journal's Philanthropist of the Year Award. A man who had been photographed at 14 consecutive White House Correspondents' Dinners and whose name appeared on donor rolls for both major political parties spanning 2 decades. According to the 162-page federal indictment unsealed 12 days later, Vincent Hargrove was neither a philanthropist nor a civic leader. He was the architect, primary operator, and controlling financial officer of one of the most sophisticated criminal trafficking enterprises in modern American history. The indictment alleges that Hargrove conceived the network in 2009, launched operations in 2010, and personally managed every dimension of its expansion, from client acquisition to victim recruitment to the labyrinthine financial infrastructure that kept $120 million in illicit revenue, invisible to regulators, law enforcement, and the public for nearly a decade and a half. He did not do it alone. The network. The federal indictment names 14 defendants. Each one occupied a defined role within a structure that prosecutors describe as operating with the organizational discipline of a multinational corporation and the operational security of a clandestine intelligence service. Hargrove sat at the apex. Beneath him, the network divided into 4 operational divisions: client management, recruitment and logistics, financial operations, security and counter-surveillance. Client management was overseen by Patricia Langford, 54, a former congressional chief of staff who leveraged 2 decades of Washington relationships to identify, vet, and onboard high-value clients. Langford maintained what internal communications referred to as the introduction protocol, a multi-stage screening process that required prospective clients to be referred by existing members and to submit to background verification before being granted access to the network's encrypted booking. Platform. Recruitment and logistics fell under the direction of Marco Reyes, 47, a former nightclub promoter and talent scout based in Miami. Reyes operated a network of front companies, a modeling agency in South Beach, a staffing firm in Manhattan, an entertainment consultancy in Las Vegas that served as pipelines for identifying and recruiting individuals into the operation. Federal prosecutors allege that Reyes's recruitment methods escalated over time from deceptive employment offers to outright coercion, including debt bondage, document confiscation, and threats of violence. Financial operations were managed by David Yoon, 52, a certified public accountant and former compliance officer at a mid-tier investment bank. Yoon constructed the financial architecture, 54 shell companies registered across 9 jurisdictions, cryptocurrency wallets cycling funds through privacy-focused blockchain protocols, offshore accounts in Cyprus, Panama, the British Virgin Islands, and Singapore. He structured every transaction to remain below federal reporting thresholds. He filed fraudulent tax returns for every shell entity. For 12 years, he maintained the fiction that $120 million in criminal proceeds was legitimate consulting revenue. Security was handled by 2 former private military contractors, Neil Driscoll, 49, and Aaron Falk, 46, who implemented counter-surveillance protocols, managed encrypted communications infrastructure, and, according to the indictment, conducted physical intimidation operations against individuals who attempted to leave the network or threatened to expose its activities. 10 additional defendants filled supporting roles, regional coordinators in New York, Chicago, Las Vegas, and Los Angeles, a technology specialist who maintained the encrypted booking platform, a real estate agent who secured properties used for operations, and 3 individuals who served as intermediaries between the network and its highest-tier clients. 3 of the 14 defendants held active federal security clearances at the time of their arrest. The investigation that brought this network down did not begin with a whistleblower or a victim's testimony. It began with a number. In September 2022, an EARS Criminal Investigation Division analyst conducting a routine review of high net worth tax filings flagged an anomaly in the returns filed by Meridian Strategic Partners LLC and 6 associated entities. The companies reported combined revenues of $28 million for fiscal year 2021. Their combined payroll covered 11 employees. Their combined office footprint totaled fewer than 3,000 square feet. The revenue-to-overhead ratio was impossible for legitimate consulting operations. That single observation initiated a financial forensics inquiry that would eventually span 19 months, involve 4 federal agencies, and produce the largest human trafficking prosecution in the history of the Eastern District of Virginia. EARS investigators traced the anomalous revenue streams to a web of interconnected transactions. Shell companies paying other shell companies for unspecified services. Cryptocurrency conversions routed through exchanges and jurisdictions with minimal regulatory oversight. Cash deposits structured in amounts of $9,500, precisely below the $10,000 threshold that triggers mandatory bank reporting. By January 2023, the EARS referred the case to the FBI. A joint task force was assembled. FBI financial crimes specialists worked alongside human trafficking investigators, Department of Justice prosecutors from the Organized Crime and Human Trafficking Section, and analysts from the Financial Crimes Enforcement Network. Over the next 14 months, the task force dismantled the financial architecture piece by piece. They obtained court orders for 23 domestic bank accounts. They executed mutual legal assistance treaty requests to 6 foreign governments. They turned 2 mid-level financial operatives into cooperating witnesses through sealed plea agreements. Those cooperating witnesses provided the final pieces: the location of the air-gapped server, the existence of the client database, and the identity of every member of the network's leadership structure. The takedown. Operation Iron Curtain launched at 4:55 am on March 7, 2024, simultaneously across 7 cities and 4 time zones. FBI field offices in Washington, New York, Miami, Chicago, Las Vegas, Los Angeles, and Houston executed 14 federal arrest warrants and 23 search warrants in a coordinated action involving over 200 federal agents and support personnel. All 14 defendants were in custody within 91 minutes. Hargrove was arrested in the master bedroom of the Great Falls estate. He did not resist. He did not speak. According to the arrest report, he sat on the edge of his bed in a silk robe and extended his wrists without being asked. Langford was arrested at her Georgetown townhouse at 5:08 am, found reviewing documents on a laptop that agents later determined contained encrypted correspondence with 3 active clients. Reyes was taken into custody at a waterfront condominium in Miami Beach, a $4.2 million unit purchased through a shell company and paid for entirely in cryptocurrency. Yoon was arrested at his home in Bethesda, Maryland. Agents recovered an additional $780,000 in cash hidden inside a false wall in his garage, alongside 3 external hard drives containing mirror copies of the network's financial records. Driscoll and Falk were arrested at separate locations in Northern Virginia. Both were found in possession of encrypted communications devices and, in Driscoll's case, an unregistered firearm. The charges. The indictment contained 84 counts across the 14 defendants. The charges included conspiracy to commit sex trafficking by force, fraud, and coercion under 18 U.S.C. 1591, money laundering conspiracy under 18 U.C. 1956, wire fraud, bank fraud, tax evasion, structuring financial transactions to evade reporting requirements, conspiracy to obstruct justice, and witness tampering. Hargrove personally faced 29 counts. If convicted on all charges, he faces a statutory maximum of 220 years in federal prison, with mandatory minimum sentences totaling 45 years on the trafficking counts alone. At a press conference on March 19, 2024, the U.S. Attorney for the Eastern District of Virginia, standing alongside representatives from the FBI, the EARS, and the Department of Justice, addressed the scope of the case. This network did not operate in the shadows of society, she stated. It operated in the shadows of power. It exploited vulnerable individuals for profit. It leveraged political access for protection. And it maintained its invisibility not through absence, but through the deliberate cultivation of a respectable public facade designed to make its crimes unthinkable. The FBI Assistant Director in charge of the Washington Field Office added a pointed assessment. The defendants in this case weaponized trust. They weaponized reputation. They weaponized the assumption that people who attend charity galas and shake hands with elected officials could not possibly be engaged in the exploitation of human beings. That assumption failed 247 people. The victims, 247. That is the number of individuals federal victim advocates identified as having been trafficked, exploited, or coerced through the network during its operational lifespan. Many were recruited through fraudulent employment advertisements, postings for modeling work, hospitality positions, executive assistant roles, event coordination jobs. The advertisements were professionally designed. The interviews were conducted in legitimate-looking office spaces. The initial payments were real. The exploitation came later, gradually, systematically. Victim impact statements submitted during pre-trial proceedings described a machinery of control built on financial dependency, isolation, and fear. Victims reported having their identification documents confiscated, their earnings deposited into accounts they could not access, their movements monitored through GPS-enabled devices provided by network operatives under the guise of company-issued phones. One statement, from an individual designated Jane Doe 14, described being recruited at age 20 through a social media advertisement for a luxury brand ambassadorship. Within 4 months, she had been transported across 3 state lines. Her passport was held by a network handler. She was 24 when agents from Operation Iron Curtain identified her at a property in Las Vegas. They called us assets, her statement read. Not people. Assets. Things to be managed, moved, and monetized. The aftermath. The reverberations extended far beyond the courtroom. Within weeks of the indictment's unsealing, 4 members of Congress issued unsolicited public statements denying any association with the network, before any legislator had been publicly named in connection with the investigation. 2 Washington lobbying firms announced abrupt dissolutions. A prominent defense contractor placed its chief operating officer on indefinite administrative leave. The sovereign list, those 37 names in the database's highest client tier, remained under seal by court order. Efforts by media organizations to unseal the list were opposed by federal prosecutors, who cited ongoing investigations and the risk of compromising cooperating witnesses. As of late January 2025, 9 of the 14 defendants had entered guilty pleas under cooperation agreements requiring full disclosure of client identities and operational details. Hargrove was not among them. His defense team filed motions challenging the constitutionality of the search warrant and the admissibility of the encrypted database. His trial was anticipated for spring 2025. The remaining investigations were active. Federal sources confirmed that additional indictments were under consideration. Step back and consider the architecture of what was built here. 54 shell companies, 9 jurisdictions, 14 years of operation, $250 million in transactions when associated revenues are fully accounted, military-grade encryption, counter-surveillance protocols borrowed from intelligence tradecraft, and at the center, a man who raised money for children's charities and dined with the people sworn to uphold the law. This was not a criminal operation that existed despite the system. It was a criminal operation that existed because of the system, because access and influence and the veneer of respectability provided a shield more effective than any encryption protocol ever could. Operation Iron Curtain dismantled one network. Federal law enforcement officials are unequivocal in their assessment that others remain operational. For 247 individuals whose lives were converted into line items in an encrypted database, justice arrived 14 years late. Their years cannot be returned. Their trust cannot be restored. What can be demanded, what must be demanded, is that the institutions charged with preventing these crimes examine not only how this network was eventually discovered, but why it took so long. The answer to that question will be more uncomfortable than any name on any sealed list.